One.
This Honorable Court of Appeals of Tennessee is now in session.
Good afternoon. Before we call the case, just thank the attorneys for the participation here by Zoom. We hope to be back holding oral arguments in courtrooms sooner rather than later now. If we should have any problems related to the technology, everybody just take a deep breath, kind of pause, and our resident experts will get it all back set up and back online again. Mr. Hibbert, if you'll call the case, please.
Marn, Suzanne, Larsen-Ball v. William Gordon Ball.
We'll hear from the appellant.
May it please the court, Tom Jesse of the Washington County Bar. I represent Mr. Gordon Ball in this matter. This case basically turns around 4 orders of the court. First being September 2007 order, which is the one that Judge Blackwood entered, granting the parties the divorce and finding that there were 7 properties, 5 of which were rentals, all of which were to be sold. We then proceed to the order entered on October 3rd, 2007, where Mr. Ball was ordered to pay maintenance expenses on all of the properties, and he has fully complied per the record with the terms of that court's order. Ms. Ball admitted during the trial that Mr. Ball paid the expenses on all of the rental properties in Destin. Mr. Ball paid all those expenses of the 5 rental condominiums from the date of the divorce until May 12, 2009, with the exception of 1 tax year that was paid on the East Pass condominium by Ms. Ball. The total expenses from the date of the final order in 2007 until the sale of the final Destin rental condominium in 2015 was $510,104.35, which Mr. Ball was to be reimbursed for. However, in the trial court's order of July 16, 2019, the court stated that Mr. Ball's records simply do not provide, and I'm quoting, the level of detail to allow the court to find that he should receive credit for all of the expenses for maintenance, upkeep, and utilities related to the various properties. And then in the February 4th, 2020 order, the trial court allowed $235,900 of approved expenses. Subtracting that from the total, it leaves $274,204.19, which are described as unapproved, and yet the judge in his order says they don't rise to his standard. A careful reading of Exhibit 22, the transcript clearly shows that these are identical expenses to the $235,000 he approved. It's a combination of canceled checks, QuickBook records, when checks were too old to be found from the bank, all of which clearly establishes that the trial court disallowed for no apparent reason $274,000 of maintenance upkeep for the Destin rentals while approving similar expenses that were submitted. Respectfully to the trial court, it's just not logical to essentially just divide it in half and approve some and not the others. The record was not disputed. No one offered any proof from Ms. Ball's side to in any way say that those expenses were not incurred, and Mr. Ball should be awarded the total expenses of $510,104.35. Similar in its ruling, Mr. Ball, we're asking, should be reimbursed for half of the interest for the 2 interest loans, that the proceeds of which were used to purchase the 2 of the Destin condominium. Ms. Ball admits that she paid no interest on Marbella or the Kelly plantation. the reasoning of the court, which just seems, again, illogical in all due respect. Judge Blackwood, in his order going back to 2007, states the parties shall share equally in the proceeds of the sale to commission, taxes, and other costs of sale. Judge McMillan, however, in 2019 says, given the property sold at different times and one remains to be sold, the court requested and anticipate that each property would have its own accounting of expenses between the parties of the divorce. There is no interpretation of Judge Blackwood's ruling other than what is clear, which is all other costs of sale. These properties would not have been maintainable had the interest not been paid by Mr. Ball throughout. We cite Norton v. Norton in that interest expenses generally constitute reasonable and necessary business expenses. The parties became tenants in common when the divorce was granted, awarding them the properties. Respectfully believe that that interest had to be paid to retain these properties until they were sold. Therefore, Mr. Ball should be awarded $324,731, which would be half of the interest paid for the two jointly owned properties.
Counsel, excuse me for interrupting. I would like to ask a question concerning the marital residence. As I understand, in the order of July the 16th, 2019, the trial court has directed that that property be sold by auction, and in part, it directs that the remaining proceeds are to be divided between the parties according to certain percentages. And then the trial court states the ratio each party is awarded is based upon Ms. Larsen-Ball receiving one half of the value of the home without improvements, $335,000, $880,000. Is there not a potential that this issue is going to have to return back to the trial court, and the trial court is going to have to address the remaining matters? So the issue becomes, is this a final judgment? And if not, did the trial court certify it under Rule 54?
Your Honor, that's a point that I hadn't actually addressed, but this could come back. I mean, it's contemplated the house will be sold, proceeds divided. They still own the house, but Your Honor is correct that that issue could cause this court to address sort of one last number on one piece of property. Yes, sir. That is true.
Thank you.
Another issue that we addressed is that Ms. Ball, the judge found that Mr. Ball kept all the proceeds from the East Pass Towers condominium. When the court looks at the numbers, one of the things that the Judge Blackwood did is he ordered these parcels to be marital property, awarded to both of them, ultimately to be sold. He awarded Mr. Ball his pension plan. On the face of it, that is contradictory in that in the pension plan were two pieces of this property. When Mr. Ball sold them, ultimately Ms. Ball was paid a total of $721,249. The IRS came in after those proceeds were paid, said the parties had to do it by quadro. There were costs and expenses. The IRS took back the proceeds until the quadro could be done, and then divided the property monies equally, with each one receiving $420,000 round figures. Given the fact that East Pass was also paid to Ms. Ball, it's our position that there's a shortage to Mr. Ball. He should be awarded an overpayment from Ms. Ball of $96,889.09. If you look at the numbers as the condos sell. Finally, the issue of receiving part of the rental account money. Ms. Larsen-Ball was awarded $144,266.48 in joint rental account. However, Mr. Ball completely funded that account from 2009 forward until 2015. The income from the rent did not handle the overhead and expenses of maintaining the condominiums. That $144,000 should not have gone to Ms. Ball. She got proceeds from the sales, but that rental account should be awarded in its entirety to Mr. Ball under those circumstances. Does the court have any particular questions as to those four issues? Thank
I
you.
hear none, Mr. Jesse. You have your time for rebuttal. We'll hear from the appellee.
Good afternoon. My name is Corinne Fulton, and I'm joining you from Hamilton County. I represent the appellee Marn, Suzanne, Larsen-Ball in this matter. Addressing the issues that Mr. Ball brings forth. First, did the trial court err in not awarding Mr. Ball 100% of the expenses that he claimed for the Destin properties? The answer to that is no, the trial court did not err in that. This is a matter that Mr. Ball simply did not carry the burden of proof to show his expenses. That was one issue. Another issue was that Mr. Ball requested reimbursement for expenses that he simply was not entitled to be reimbursed. He double dipped. He was asking to double dip. For example, Mr. Ball represented to the court that he was entitled to be reimbursed 1/2 of various expenses for property taxes, HOA fees, and utility fees. Through cross-examination, we were able to discover those fees have already been shared by and between the parties because those were paid from the joint rental account. So no one needs reimbursed. So he lost some of his expenses that way. Another way was that Mr. Ball represented to the court that he was entitled to be reimbursed for taxes and HOA fees for various properties. Through cross-examination, we were able to show that those were paid out of the proceeds from the sale of those properties. And so the parties already shared in that expense, and he was not entitled to be reimbursed. So he lost that argument. Another argument was he was trying to seek reimbursement for taxes that he said he paid, and we proved that he never paid those taxes. Those were taxes that Ms. Larsen-Ball had paid, so he lost those expenses. This is not an issue of the baby splitting the court. This was a matter that Mr. Ball requested twice the amount of expenses that he was able to prove, so the court did not err in that. Moving on to the second issue Mr. Ball brings on appeal. Did the court err in not giving him reimbursements for 1/2 of the interest paid on the 2 loans? The answer is no, absolutely not. In the order entered September the 3rd of 2007, subsection paragraph L, it states, and I quote, "The husband shall have the remainder of property on Exhibit 1 and any outstanding debts not heretofore covered in this judgment." The payment of those loans fall into that category as outstanding debts not heretofore covered. Both of those loans were in his name alone, and he was not entitled to the interest. To further bolster our argument, if you read that order, you will see that the trial court actually took the amounts of those loans as they existed at the date of divorce and subtracted them from the values of the assets to get a net value, saying the parties shall share in this, the net, which did not include any interest, or it did not include any increase in those debts. So that issue was properly decided. Next,
Counsel, excuse me for interrupting. I would like to address the same issue with respect to the marital residence. Is there a final order or final judgment in this case with the language being that the ratio of these percentages for the sale proceeds once the marital home is sold? It's my understanding it's not sold at this point in time. The ratio each party is awarded is based upon Ms. Larsen-Ball receiving 1/2 of the value of the home without improvements and Mr. Ball receiving the remainder. Is there not potential that this issue is going to have to go back to the trial court for the trial court to address any questions?
I don't believe so, Your Honor. I believe that that is a final order because once the property is sold, we already have a parameter of what expenses the parties are to share in. The judge has already ruled on that. It was ruled on that in 2007 and again reiterated by McMillan in the most recent orders. So I believe that if there is an issue with dividing that percentages as he put down, that the parties can bring it back to the court to say what reimbursements are available, and they can just order, he can rule on that one issue. But I don't believe that that makes this order not a final order. That is something that he has given marching orders on and that parties can successfully complete.
Well, if the trial court is going to have to address another issue or multiple issues with regard to the sale or the sale amount or the proceeds, and the trial court has not certified this order under Rule 54, then is there a final judgment?
Well, Your Honor, we can't speculate on whether the trial court will have to have another hearing on this. He has already outlined what reimbursements are appropriate, how the proceeds are to be divided, and I believe that the parties can execute on that. Oftentimes in divorces, the judge will rule a property is to be sold, the parties are going to divide the proceeds, and the inclusion of that does not make that order not a final order. And there is no determinate factor that the parties will be back before Judge McMillan on that issue. So I believe that this court can properly decide all of these issues on appeal. I believe that this is a full and final order.
Thank you.
Thank you, Your Honor. Going back to the next issue brought up was the sale of East Pass and whether the court erred in finding that Mr. Ball kept all of those funds. The court did not err in that. Mr. Ball did keep those funds. He issued a $20,000 check to Ms. Larsen-Ball. The court corrected that, its ruling upon Mr. Ball's motion to alter or amend. But essentially what Mr. Ball is really asking the court to do in that section of his brief is he's asking for full credit for paying Ms. Larsen-Ball a check of $570,000, even though he fully acknowledges she had to return that check plus about $1,000 in interest. But he wants credit for $570,000 when she never kept it. She actually only received $431,000. So he properly lost that argument. The last argument that he makes is about monies owed from him to Ms. Larsen-Ball from the joint rental account, and that was absolutely appropriate. After the parties funded the joint rental account with joint money, approximately $389,000, Mr. Ball almost immediately issued a $315,000 check to go to SunTrust to pay his business interest loans. And the memo of the check actually shows that. That is not a prescribed expense pursuant to the May 12, 2009 order. So Judge McMillan said that was not an approved expense. You will pay her back 1/2 of that. Additionally, Ms. Larsen-Ball presented at trial that that was not her signature. She presented many other checks that she wrote from the joint account around that same time to compare the signatures from the ones that she testified to were hers and that one. And there is a marked difference. So Judge McMillan did not err in that ruling. However, he did omit a $30,000 deposit that Ms. Larsen-Ball should get credit for, 1/2 of that. And that was a $30,000 deposit from the proceeds of the sale of the Waterview boat slip. And in my brief, I point to the exact exhibit that shows that that was deposited into the joint rental account, and that was something that the judge just omitted. So his order should be revised to reflect that she should receive $159,266.48 from the rental account. Moving on to the issues Ms. Larsen-Ball brings up on appeal. Did the court err in not finding Mr. Ball in civil contempt for failure to pay her the funds when those properties were sold, and awarding her damages and attorney's fees as a result? The standard of review for this issue is abuse of discretion. A trial court abuses its discretion when it applies an incorrect legal standard, reaches an illogical conclusion, bases its decision on a clearly erroneous assessment of the evidence, or employs reasoning that causes an injustice to the complaining party. In this case, we have that. We have 3 orders that were very clear, and Mr. Ball is an experienced, seasoned attorney who knows how to read those orders. His argument is that him not paying her 1/2 of the proceeds was not willful because the order did not say when he was to state that. That argument strains credulity to insist that Mr. Ball was appropriate to keep her half of the share of the proceeds and enjoy those for almost a decade. East Pass property sold in October of 2011. Except for that $20,000 check, Ms. Larsen-Ball has not been paid her share of the proceeds. Still, Marbella sold August of 2011. And on all of these properties, Mr. Ball actually received the funds. And he still has not paid her share of that. Unit 623 sold in January of 2012. Ms. Larsen-Ball finally received her share of those proceeds almost 2 years later via a quadro. So Ms. Larsen-Ball is asking for Mr. Ball to be fined $50 for every day in which he held proceeds and has not distributed or did not distribute those to her. Moving on to the basketball tickets, he was ordered to submit to her 1/2 of the basketball tickets. We established that he received 4 women's basketball tickets, 4 men's basketball tickets. We established at trial that each had 8 to 9 home games per season. There was 340 acts of contempt by him not giving those tickets to Ms. Larsen-Ball, $50 each. That's $17,000 that he should have been fined. Now, Mr. Ball says, well, Ms. Ball didn't receive tickets because she didn't pay for those. There is no order that requires her to pay for those tickets outside of the years of 2007 and 2008. The court speaks through its orders, and we don't have that. So there is nothing that requires future payment to receive future tickets. With the Bank of American funds, Ms. Larsen-Ball is asked $50 to be fined to him for each check or unauthorized disbursement from that account that does not comply with the May 12, 2009 order. We established at trial 63 total events where improper disbursements from that account, $50 each, that's $3,150. She also requests her attorney's fees, and attorney's fees are considered compensatory damages. Such a finding of no civil contempt goes against the evidence of this case, and it causes a great injustice to Ms. Larsen-Ball. There is no recourse or remedy for which Mr. Ball is held accountable for disobeying the orders of the court. Next, did the trial court err in denying mandatory post-judgment interest to Ms. Larsen-Ball? It did. Post-judgment interest is statutory. Tennessee courts have routinely held that post-judgment interest should be calculated from the time the party was entitled to use the funds until the time.
Counsel, I'm sorry, before you leave the contempt, I mean, didn't the court find that both parties had acted as they pleased in disregard of the court's orders?
The court did find that, Your Honor, and I don't believe that that was an appropriate finding. And as we see in domestic cases, there's also, we talk about abuse. Well, there's financial abuse. And in this case, Mr. Ball was the only one in control of the funds. Mr. Ball was the only one in control of the reimbursements. Mr. Ball was the only one who kept those records. Mr. Ball was the only one who had the ability to comply with the order. And it wasn't until Ms. Ball finally said, I'm tired of you abusing me financially, and took him to court to try to get this remedied. But she complied with the orders. Mr. Ball did not comply with the orders. She did not have the power to do anything other than to comply with the orders, Your Honor. So the post-judgment interest in this case should be calculated from the date that Mr. Ball actually received the funds and failed to disperse them until He finally made her whole. And on some of those properties, as I've discussed, she has still not been made whole, and post-judgment interest should still be running. Mr. Ball says, well, there's not a judgment. Again, because there's no time stated when I have to pay her that money. That flies in the face of logic. There are no proceeds to divide until the house is sold. The houses and the property were ordered to be sold in September the 3rd of 2007. Proceeds don't exist until they sell. Mr. Ball received those proceeds, he kept them, and he has enjoyed them. Mr. Ball also appealed this original order all the way up to the Tennessee Supreme Court. He never argued that that language was vague, that he didn't understand anything. Mr. Ball never argued to change the order on the interest for the loans. He is stuck with the orders from the lower court, and he's now trying to get it changed several years later. The other issue is, did the trial court err when it denied Ms. Larsen-Ball 1/2 of the fair market rental value for Old Kent? And it did. Mr. Ball had possession, control of the property, and he actually profited from the property. I see that my time is up. Your Honors, may I finish my argument?
You can finish your thought.
Thank you.
Yes, not the rest of the argument.
Yes, sir. Yes, sir. He had possession, control of the property, and he ousted Ms. Larsen-Ball. He changed the locks several times, never giving her a key, did not give her the new code to the garage, and he profited from the house. He profited because he ran his law office from that house for a number of years. He had employees in that house, and he was not paying rent anywhere else. Additionally, he's profiting because Judge McMillan, in the July 2019 order, where he changes the division of those proceeds from 50-50 to where Ms. Larsen-Ball is only receiving 43.75%, he did so to repay Mr. Ball for the amount of money that he invested into the property, into that house, which he did so to his own detriment without the knowledge or consent of Ms. Larsen-Ball. And under the law,
Counsel, your time's expired.
Thank you so much.
Thank you. We'll hear from the appellant rebuttal, Mr. Jesse. Mr. Jesse, I think you're still muted.
Excuse me, as Your Honor has stated, the July 16th, 2019 order clearly provides that neither party followed the various orders of the court. They did what they wanted to do with proceeds. They used the properties. Ms. Ball was never denied access to Old Kent, for example. As the court says, by a preponderance of the evidence, the court cannot find that Mr. Ball's use of the funds, which is the rental account, was without Ms. Ball's permission, and her request that Mr. Ball be found in civil contempt is denied. They remained friends, acquaintances, whatever, throughout this. Interestingly enough, Judge Blackwood said if anybody is, either of the parties is not happy with where we are in this, within 8 months of the final judgment, either party has a right to demand sale at auction. Ms. Ball never asked for anything to be sold. She was comfortable with the way the things were being handled. And that court order says commissions, taxes, and any other costs without someone paying the interest, paying the regime fees, paying the upkeep fees, there would have been nothing to sell. If your court will recall, the end of 2007, we went into one of the worst economic crises since the Depression. These properties were on the market
Mr. Jesse, I don't know if you can hear me, but I think we've lost you. You're frozen. Can't hear you.
one half of the interest, she admits she paid none of those interests. Then on the question of judgment of $144,000, as the court said, although he gave her $144,000 out of the rental account, the court did find, and it seems to be in conflict, that Mr. Ball's use of those funds was without Ms. Ball's permission, and her request that Mr. Ball be found and condemned is denied because he could not find that those monies were spent without her permission. You know, it was 6 years of trying to move these condominiums, and he was paying 100% of it. And we can talk about, yes, this case originally came to the Court of Appeals and to the Supreme Court. These parties each split over $11 million each from the marital estate. Ms. Ball was in no way economically overburdened, confused, or anything else. She maybe should have done things differently than she did, but had Mr. Ball paid what he paid to preserve the marital assets, they would have all been foreclosed. So respectfully, we ask, as our summary and our brief on page 28 and 29 sets forth the numbers we believe Mr. Ball should be reimbursed.
All right, thanks to counsel for both sides. We appreciate your briefs and your oral arguments on this. Mr. Hivner, you please recess court till our next scheduled argument.
This honorable court is now in recess until 3:30 p.m.